We need to get started because you know how prosecutors like to talk. Yeah, that did it. Thank you very, very much. I would first like to start off with one introduction that I saved until now, and so I would like to welcome the prosecutor from Cambodia. I'd like to welcome Andrew Cayley. Please welcome Andrew. Now, leading the next session is one of our sponsors. I mentioned that earlier. And I will just try to identify Professor Scharf's title, because if I went any more into an introduction on Professor Scharf, the prosecutors would have no time to talk. And so I would like to say this session will be moderated by Professor Michael P. Scharf, the John Deaver Drinko, Baker, and Hostetler Professor of Law and Associate Dean for Global Legal Studies at Case Western Reserve University School of Law. Did I get it all? Okay, thank you very much.
You know, Jim, all you had to say is, he's the band. For those of you who are staying at the hotel, we did a little jamming last night. The prosecutors sang along with us. We're going to do it again tonight, so something to look forward to. I am Michael Scharf, and it is a very great pleasure to once again be invited to moderate this particular panel, which I consider the high point of the dialogues, or one of the high points at least. I want to start with a special announcement to tell you something about our host, Jim Johnson. He's no longer just former Chief of Prosecutions Jim Johnson or President of the Jackson Center Jim Johnson. He is now Professor Jim Johnson. He's been appointed by the case faculty as an adjunct professor. He is co-teaching our War Crimes Research Lab, in which we have produced 350 memos for all of these prosecutors up here, and will continue to do so now under his capable hands. So thank you, Professor. Now, the prosecutors have already been introduced, but I want to tell you a little bit about some personal connections which will be relevant to the way we proceed in this panel. Let's start with Fatou. A year ago, almost to this day, she was at my house for a barbecue when she was at the law school to get the Case Western Humanitarian Award for advancing global justice. And then we went to the Rock and Roll Hall of Fame, where I found out that she was the national dance champion of her country. So, Fatou. Brenda Hollis is actually an honorary alumni of Case Western, having received the honorary doctorate degree 2 years ago. Serge Brammertz lectures every year at the Summer Institute that Case Western Washington University co-hosts for David Crane's course in Utrecht. So he's part of the family. Andrew Cayley, well, my home away from home during my last sabbatical was the office next to his, where I spent a semester, and so I feel like we have that in common. And then, of course, Hasan Giallo. I've been to his tribunal and had the privilege to lecture there several times, and his hospitality is world-renowned, and so we all have a connection. Now, why is that relevant? That's relevant because the format for this is going to be like the McLaughlin group. Instead of having each of them speak for 15 or 20 minutes, we've divided it up into some questions, and I will be peppering them with follow-up questions, and it's going to be a much more interesting interchange, and hopefully there'll be time at the end for your questions as well. So since you know that we have this close relationship, you won't think I'm insulting them when I'm asking them the tough questions, because they can take it from me. All right, so we're going to start with Andrew Cayley, because he said, I don't know, he said that he has the least to speak about, so he wants to go first. That's not at all true. But here he is to my right. And things are happening at the Cambodia Tribunal. They're in the middle of this uber trial of the top Khmer figures who are still alive. Now that who are still alive is a big caveat because they started with 5 and they're down to 2. But it's an exciting trial, and there are questions about whether there will be a follow-up trial that will expand the scope, and there's all sorts of political currents going on, and everything that's going on in Cambodia is interesting. So the first question for the panelists, and we'll dive in with Andrew, is what was one of the most important developments at your tribunal during the last year?
Thank you, Michael. If I could just say a little bit, certainly for the people who are here, who are not the sort of immediate members of the legal fraternity and know about this court. Very, very briefly, it's called, the court I work for is called the Extraordinary Chambers in the Courts of Cambodia. The shorthand for that is the Khmer Rouge Tribunal. It started functioning properly in 2007-2008. It's a very special kind of court, special actually in difficult ways, in that uniquely amongst all of the courts, although the Sierra Leonean court, for which Brenda is the prosecutor, has certain similarities, it's a domestic court. So it's actually the agreement that was come to between the United Nations and the Cambodian government would be that the remaining senior leaders and those most responsible for what happened during the Khmer Rouge period, 1975 to 79, extreme Maoist communist government came to power and essentially murdered, starved, or worked to death 2 million people in the space of less than 4 years. So those are the crimes that we're looking at. The UN decided to set up a court with the Cambodians, so it is a national court. It's not actually really an international court. It's a national domestic court with certain internationalized features. So there are Cambodian lawyers, prosecutors, judges working in the court alongside internationals. So that's just to give you a flavor of what this court's about. That brings many, many problems because the government have a very understandable interest in how far the court goes, who is prosecuted, because there are many members of the Khmer Rouge who have been reintegrated into Cambodian society. The civil war went on in Cambodia long after the Khmer Rouge fell from power, and one of the government's interests is to reintegrate many of these people, hundreds of thousands of them, into the country as a whole. So there is a tension between that and trying these former senior leaders of the regime for these terrible crimes. So, understanding that, the most important development. We've had 2 cases. The first case that we finished concerned the commander of a camp called S21, which was the central security camp. It was the central part of a security apparatus that the Cambodians ran, arresting people that they regarded as counter-revolutionaries, often on very flimsy grounds. I don't know if any of you have ever been to Phnom Penh. It's now a museum. But oftentimes, that didn't mean just the person that was regarded as a counter-revolutionary. It involved the whole family. It also involved people who were educated. They were regarded as counter-revolutionaries. So within this camp, in the space of 3.5 years, 15,000 people were murdered. We've completed that case. What is the most important development? Well, the most important development is that we are coming to the end of the second case, which did originally involve the 4 most senior leaders still living of the Khmer Rouge period. Unfortunately, we lost one through mental incapacity, a lady called Ying Tirrit, who was the Minister of Social Affairs. She had the early stages of senile dementia when we actually started the trial, and then during the trial we lost her through incapacity. But this was actually a very important development domestically because the country literally has no developed legal system. So you're dealing with a country where people who are lacking mental capacity are constantly appearing in front of domestic courts, being tried and convicted. For the first time, although we lost this individual, we actually demonstrated to the domestic system that these issues are important, and even somebody accused as serious of crimes as she was accused of, that we would basically ultimately not allow her to walk free, but certainly separate her out of the proceedings because she was no longer mentally capable. Unfortunately, this year, her husband Ying Sari, who was the foreign minister, died in March of this year. So we're actually down to 2 accused. Now, we also have a lot of financial problems because the court is voluntary funded. I'll talk a little bit more about that in a moment. But we are now coming to the end of that second trial. And a lot of the fair weather critics of the court said that we would never, ever bring this case to a conclusion. Within the next 3 weeks, actually 4 weeks, we're about to file our final written submissions, and then in October we will have oral submissions. That will be the end of that case. We hope that the 2 accused live long enough so that the trial chamber can come to a judgment. But I think that probably is the most important development of this past year, that we are bringing case 2 to a close.
Okay, excellent, very much in the economical spirit of this format, so thank you very much, and we'll return to you for some tougher questions in a minute. Let's then go to Brenda Hollis, whose tribunal is coming to a close, and she's been there for so very long. The Taylor appeal is expected, I believe, in September. Meanwhile, Brenda was confiding to me that the ICTY's recent precedents that Serge might tell us about on aiding and abetting are keeping her up at night a little bit. Brenda, tell us about the most important developments at the Special Court for Sierra Leone.
Sure. I have 50 pages of comments. As was just mentioned, we have completed the appellate submissions in the Taylor case, and we should have the judgment in that case no later than the end of September, perhaps a little before that. That's significant, but I don't think the most important development in the last year. We are also moving to close our court. We will be the first court to actually close since Nuremberg. That's a lot of work, and that's significant, but again, I don't think it's the most important development in the last year. What I think is the most important development is the conclusion of criminal proceedings against 5 individuals charged with contempt of court for interfering with witnesses, including attempting to bribe witnesses to change their stories. They were convicted on the evidence, and sentences range from 18 months suspended for a person who pled guilty and assisted the prosecution to 2.5 years. 2 of the individuals are currently serving long-term jail sentences for crimes against humanity and war crimes, and their sentences were to be applied consecutively, which is, I think, important as well. Now, why is that the most important development for me? We will be closing. There will be a residual court that will have the ability to prosecute people for contempt, but many people don't know that or don't acknowledge that. And so they are of the view that once we close, they can come out and take their revenge on people who have had the courage to come forward and testify. So the fact that we went forward very aggressively, asking for investigations into this interference with witnesses, that the judge reviewed the evidence and found them guilty, and that the persons who actually did it, perhaps not the planners, but the ones who actually did it, were then sentenced to jail, for me is a very significant development, because I believe risk to our witnesses and risk to our sources will be very high when we close, and this is a reminder to everyone that if you do it, you may very well face prosecution and end up in jail. So I'm hoping that that development will help to protect these courageous people without whom we would not be in business once we actually close our doors.
Excellent. And now let's turn to the Rwanda Tribunal, Hasan Giallo. I understand you're finishing appeals, you have cases going to Rwanda, and you are now working on your own residual mechanism. Tell us about what's going on in Arusha.
Well, December last year, with the delivery of judgment and the conviction of Augustin Ngirabatware for genocide, we actually finished all our trials. And we concluded all of them. After some 93 indictees, we finished the trials of most of them and secured some 63 convictions and 12 acquittals. We referred some of the cases to Rwanda for trial and 2 to France. So we have finished the trials of our cases finally, and now we are focusing on the management of the appeals, which we anticipate will finish by the end of 2014, except for one case, the Butare case, which involves 6 accused. And this is largely because it's the biggest case we have. It's got a voluminous record involving, heavy translation duties, and as a result, it's going to take up to September of 2015 to finish that particular appeal. So the trial's over, focused on appeals. We're also focusing on a number of legacy projects which we've been working on, some of which have been concluded, including lessons on the investigation and prosecution of sexual violence, lessons on transfers of cases, and how this could relate to the complementarity regime of the ICC, et cetera, et cetera. Of course, I wear a double hat. I also have to deal, as prosecutor of the mechanism, with the residual mechanism. The mechanism is the successor to the ICTY and the ICTR. It will take over certain functions from both tribunals. And since 1st July last year, we got the Arusha branch up and running. It's focused on the tracking of the remaining fugitives, which fall under its jurisdiction, on the management of the archives and witness protection. And in July of this year, we managed to also get the Hague branch of the mechanism off the ground, and it's now functioning as well. So that's where we are. So the major development for us really has been conclusion of the trials in the ICTR and the commencement of the operations of the residual mechanism.
Well, thank you for bringing us up to date on the Rwanda Tribunal. If I saw some puzzled faces trying to figure out how we put the people in order here. This is Jim Johnson's conception. He wanted to go male, female, or as he said, boy, girl, boy, girl. So now to Fatou Bensouda, who was deputy prosecutor for 9 years and now is in her second year as chief prosecutor at the ICC. Fatou, you've got all sorts of places around the world that are keeping you up at night, I'm sure. The Libyans aren't turning over Gaddafi or Sanusi. The Kenyan witnesses are refusing to testify. The court has said that the Gbagbo case must be stayed until you get more evidence. I'm curious as to what you would consider the most important development in the last year.
Thank you, Michael. First of all, I just want to say hi to everyone. This is an opportunity for me to do that and to also express how happy I am always to come. I've come 6 times now, so that should be testimony to the fact that I love to come. What was the most important? Where do I start? I mean, it's a lot of things that has been happening, as you know, over the last 1 year at the court. Many developments have taken place. I recall when my deputy, I now have a deputy, when he was being sworn in, I told him that there is never a dull moment in this place. And he thought I was joking. But I think a few years into his holding office, he does agree with me that there is really never a dull moment at the ICC. But let me just take a couple that I think I can give as examples of important developments that have taken place at the court. And one of them is Ngujolo's acquittal. You will recall that Matthew Ngujolo was charged together with German Katanga. And last December, the judges of the trial chamber decided to acquit one of them, Matthew Ngujolo, of all charges. Of course, this is disappointing for the office that he was discharged, he was acquitted. But I think it's also important to show that this is a judicial process. And justice is not all the time about convictions. If that is what the chamber feels, that we have not been able to present all the evidence that the chamber needs to convict him, that is their decision. But as an office of the prosecutor, of course, we don't agree with that decision. We have appealed it before the appeals chamber, and we are fairly confident, or we think that we have put a strong case before the appeals judges for them to revisit the decision that has been taken by the trial chamber. So I think that is quite important. But another one also is the surrender and transfer of Bosco Ntaganda. Again, you will remember that Bosco Ntaganda was charged together with Thomas Lubanga. It was one of our first cases. We decided to unseal the charges against Thomas Lubanga when we got an arrest, and then we kept Bosco Ntaganda sealed for some time until later, when we thought that it was a good opportunity to now unseal the charges against Bosco Ntaganda. But even then, since then we had been calling for the arrest of Bosco Ntaganda for, I think, more than 5 years. And all of a sudden, last March, Bosco Ntaganda walks into the US Embassy in Kigali and surrenders himself. And I think this is very important. It shows we were able to work with the US very closely, very cooperatively. They assisted the ICC for Bosco to be transferred to the Hague, because that's what he was asking for. He wants to go to the Hague, and quickly the US authorities were able to say that we will assist Bosco Ntaganda to be transferred to the ICC, and they did that. It was a very well-coordinated, seamless transaction that we did for Bosco to come to the Hague. But also behind that, I think it also shows that we need to start thinking about arrest strategies that we can develop at the court. With Bosco Ntaganda, there has been a lot of background messaging, sent to some of the ICC indictees whom we can reach, to also encourage them, if they want to surrender to the ICC. This is important for them to do. And we have worked with many international organizations, many states parties, even non-state parties. We've worked with them. And whilst we cannot say that this is a direct result of what was happening in the background, we certainly think that it has made an impact for Bosco to be able to get the right message and to surrender himself to the ICC. So this is important, and I think it will also, it's important especially for the victims of the crimes that have been alleged to have been committed by Bosco Ntaganda. At least the victims will see that the person who's alleged to be responsible for those crimes will be held accountable before the ICC. I think that is also important. Maybe I just want to mention the Mali, possible third example, is the Mali investigations. You will also recall that 1 month after I was sworn into office, in July of last year, 2012, the Mali authorities came to my office and referred yet another African situation to the ICC for investigations and prosecutions. I've taken time in my office to look into all the elements of why the ICC should open investigations. In fact, as soon as they referred, I opened preliminary examinations to collect information and analyze it in my office and see the possibility of opening investigations, which has been done. And it's not an easy situation in Mali, as you can see. I have been able to put together a team. We've started the investigations itself, but there was all this insecurity, as you know, that was taking place in Mali, and we have been able to engage with organizations such as UNESCO, such as ECOWAS, and even the African Union, as well as the United Nations Stabilizing Mission in Mali. We are working very closely with them. Where we need to get into agreements, we are doing that to be able to start our investigations properly and see how they can assist us in that regard. Kenya is also another example that I can give. You will recall, you will see that Kenya has emerged this year from some very important elections for them, but elections also that I think is very different is very different from what happened previously that led to the ICC cases. And whilst I cannot say that the ICC was responsible for that, but I do believe that history will judge the ICC as having probably contributed to the different type of elections that Kenya has just conducted earlier on this year. But again, it is one of those cases, as you know, that is very, very challenging. We are facing huge witness protection issues. We are facing tremendous efforts being made at reaching our witnesses, at bribing our witnesses, at trying to apply pressure on our witnesses not to testify for the ICC. And also the fact that now those who are wanted by the ICC are the principal, the president, deputy president, and Sang. It's not making things easier. It is extremely difficult to find out who will ultimately be held responsible for interfering with the witnesses, because as you know, whatever is being done is done in a way, very professionally, in a very covert way that for us, it is proving difficult to know why some of the witnesses are asking to be, not be witnesses any longer. Some have actually come out to tell us that my father or my mother or my wife is saying that I should not be a witness and I do not want to break off with my father, or I don't want my community to cast me aside. So we're having these difficulties. But the trials will go on. The trials are coming on the 10th of September. Next month we'll have the first trial against the Deputy President and Sang. And in November, the trial for the President is scheduled to start. So I think I spoke more than all of you.
But you know what? With so many situations, it's one thing to narrow it down to one case, but to narrow it down to 4 is actually quite an achievement, Fatou. Now let's turn to Serge. Serge, I have to tell you, 20 years ago when I was at the U.S. State Department as part of the team that drafted the statute and rules for your tribunal, I don't think we thought it was going to still be going 20 years on. And yet, things are as exciting as ever up in The Hague. You've got Judge Harha accusing President Marone of improprieties. You've got surprising acquittals on appeal. So I'm real curious as to what you'll say was the most important development of the year.
Thank you very much, Michael. Good morning, everybody. Indeed, I have also the pleasure and privilege for being here for the last 5 years since I'm in my current function, and every year when I'm speaking about where we are, I'm saying we are moving close to the end, and I'm saying the same today. And indeed, we had our 20th anniversary, and it's a very strange feeling if for an ad hoc institution you have a 20 years anniversary. But we have, of course, also to be aware that one of the main reasons is that it took so long to have all the remaining fugitives arrested. And as Fatou said, the non-arrest of indicted persons is, I think, today the biggest challenge for international justice, and it has been the biggest challenge for our tribunal. It has taken 15, 17 years to have Karadzic and Mladic arrested, and Hadjic, the last one, was also only arrested in 2011. I also agree with what Bin Zayed said earlier, that in the field of international justice, we have to look at the delayed justice denied in a different way, because the timing factor is very, very important. By choosing the wrong moment to indict or to try to arrest, you can have an extremely negative impact and being unsuccessful. So I think timing is a factor, unfortunately, which is of importance to us. But I'm still saying that we are this time entering the real final phase, because we had the start of the last trial, the Hadjic trial. Interestingly, Hadjic, who was the political leader of the Serbs in Croatia, those were crimes committed in 1991, so the last trial is in relation to crimes which have been committed in the early days of the First War in Croatia. The trial is moving on. Trial proceedings should be over in the middle of next year, as should be trial activities in Karadzic and Mladic, which of course are two of our main accused, who are also, it is, I think, quite interesting to note that the two most important trials since the existence of the tribunal, together with the Milosevic trial, are also taking place at the very end of the tribunal. Both cases are proceeding well, and trial activities should be over somewhere in the middle of next year, with, of course, some additional time for judgment writing. For those who are not so familiar with the wars in the former Yugoslavia, you know there have been wars in the Croatian part, Kosovo, and the most important one, if I may say, in Bosnia, where between 92 and 95, more than 100,000 people lost their life. Very often, a comparison is done with what is happening today in Syria in terms of number of victims. And Karadzic was the political leader of the Serbs in Bosnia, and as such, we consider him as the political architect of the campaign of ethnic cleansing and genocide in Srebrenica, where in a few weeks' time, more than 7,000-8,000 people have been killed. And Mladic being his highest officer, being the military leader of the forces there. So our last trial started in 2012. All trials should be over somewhere in 2014, with judgment expected in 15. We also started the last appeals proceeding, Perlich and others, where the the notice of appeal was made 2 days before the start of the residual mechanism, only to say that the start date of the residual mechanism, which was 1st July this year, was the starting date to decide that all new proceedings which were initiated after 1st of July would go to this mechanism, not anymore with ICTY. Those initiated before would stay with ICTY. So as a result, because 2 out of 6 accused launched the appeal or the notice of appeal 2 days before the start of the MICT, it means that this multi-accused case will stay with ICTY. It will not make the Security Council very happy, because it means that those appeals proceedings will now stay with ICTY. It's a 2,600 pages judgment in French, which has to be translated for the next 10 months to come. It will probably take until 2017 before this case is concluded, which brings me again to the beginning of my comment to say every year I'm saying we're getting close to the end. But we were all thinking 2 months ago that this appeal proceeding would go to the MICT. In that case, we could have closed the tribunal in end of 15. Now with this change in proceedings, I will be able to report for the next 3-4 years about moving closer to the end. Thank you.
You know, it strikes me, hearing all of you in seriatim like this, that you really were well picked, because you're a bunch of upbeat people dealing with horrible crimes, and yet you have such optimism. But I want to push you a little bit, and I want to use the vehicle for that, this new issue of the Journal of International Criminal Justice, which has a symposium that basically is called Recent Setbacks for International Criminal Justice. And so your rosy portrait is apparently not being shared by these academics. Let me quote a couple of the things. This one's from the first article. It says, 10 years after the establishment of the ICC, it is difficult to deny that the project of international criminal justice is increasingly coming under pressure. Well, pressure, I guess, isn't so bad. David Lubin, he says, the dismal proposition that the momentum for international criminal law seems to be gone, and its success story, starting with the creation of the military tribunals at Nuremberg and Tokyo, and culminating in the adoption of the Rome Statute, has come to a close. Well, that is quite a depressing way to put it. Diane Ortlicker, an old friend and colleague of many of ours, she says, a series of developments, both doctrinal and political, seem to signify a retreat from earlier innovations in the law and practice of international justice. And then we have Payam Akaven, who used to work at the Yugoslavia Tribunal, saying the era of romanticism of international criminal justice ushered in during the 1990s is over. So what's going on that creates all of this negativity is the subject of our next question, and that is, what is the most controversial development related to your tribunal in the past year? Andrew?
The most controversial development is actually a headache for a lot of people, including Ambassador Rapp here, who I was talking about this with him this morning. The case that we're dealing with at the moment that I mentioned, case 2, was an absolutely massive case in terms of the number of crimes that one was dealing with. So it dealt with a 3.5-year period. It dealt with many, many crimes, not just killing, forcible transfer of the population, forced marriage. People were forced into marriage. The regime decided that as a policy. There was a lot of destruction of religious and cultural property. And because the judges in the case realized that because of the age of the accused, I mean, we're talking of accused all in their late 80s, that we would never actually finish the trial if we dealt with all of these crimes. We'd be involved in literally a 7 or 8 year trial of very elderly people who are likely to die. They decided to what's called sever the case, which means that they wanted to divide it up into smaller chunks so that we would get through a small part of the case, hopefully get a conviction at the end of it and not spend 5 years. Well, we've actually just spent 2 years dealing exclusively with the issue of forced transfer. At the beginning of the regime, they decided that they would forcibly move the population from the urban centres into the countryside to work principally in work cooperatives. Now, the problem with that is that one of the principles that works in this field of law is that you address the most serious crimes. And the forcible transfer, whilst a serious crime, was not the most serious crime when you consider that nearly 2 million people either died or were murdered. Now, what I tried to do during this first segment of the case was to convince the judges to just include some killings within that first segment. Then at least if we got to the end of this first part, this first case 2 part, and the accused all, lived long enough, and now we know we only have 2 left, that we would not just have a conviction for forcible transfer, but we would also have convictions for murder. They didn't follow the applications that we made, the prosecution. We appealed it. I won't go into all of the details of the appeals, it would take too long, but a very controversial decision was made by the appeals chamber recently to essentially advise the administration of the court to look into the prospect of setting up a second trial chamber whilst the judges are still deliberating on this first case involving forced transfer, to set up a second trial chamber to deal with these other more serious crimes. Now, unfortunately, this brings enormous problems. The court has no money. It's running out of money. It means that one would have to redeploy judges within the court, recruit new international judges to start this second trial. It also means actually starting a second trial of the same subject matter, maybe before you even have a judgment in this first section on forced transfer, and certainly before you even have an appeal on this first section of the case. That is probably the most controversial area. Equally, the agreement that was signed between the United Nations and the Cambodian government, if you look at it, and if you look at the domestic legislation that created the court, it's not very clear whether a second trial chamber was ever envisaged. So we're running against this tension of wanting to try and address the more serious crimes with very elderly accused. I mean, these people are dying without really a legal basis. Perhaps it's arguable. Some people say maybe you can have a second chamber. Some people say you can't. We certainly can't wait until the appeal is finished in this first section on forced transfer, because that will probably be 2015, 2016, by which time these accused will be dead. So that perhaps echoes some of the problems that these writers are speaking about. I don't know how this will play out in the end, but I do believe it would be a very, very great shame if these 2 senior leaders were never confronted with the most serious crimes that were committed during their tenure.
Okay, well, thank you for your candid assessment there. I think that gives us all some pause, and our hopes are with you that both the they will live for another trial and that there will be the political will and the funding, because, boy, it would be awful if the only thing they were ever convicted of was transfers, not even killings, after setting up this entire tribunal, which most people call the genocide tribunal. Well, Brenda, things have been going a little bit better, I think, at the Special Court for Sierra Leone.
We'll see in a month how much better.
Yeah. Tell us about the most controversial development related to your tribunal.
Actually, the most controversial development for us was not in our court, but rather in the ICTY and the appeals chamber decision relating to aiding and abetting. And Mr. Taylor was convicted of aiding and abetting throughout the entire indictment period, and also of planning an operation that took place near the end of the indictment period, or I should say in the middle of it. So the aiding and abetting is the bread and butter of the conviction, and the case at the ICTY and other cases that may flow from it, the Perisic case, directly impact on what is required to prove someone guilty of aiding and abetting. So that's the most controversial development for us, and I would imagine that Serge will talk about that as well. But before I make any more comments about that, I think that we really do have to congratulate the ICTY on the ingenuity of celebrating a 20th anniversary of a court that had a 3-year mandate. That I think is well done, Serge. And we're moving forward. Maybe in the next 3 years it will end, so they'll meet that 3-year mandate.
Brenda, you worked there before I arrived.
That's right, yes, that's right. We indicted all those people they wouldn't hand over, yes. And I do think that's an important point, though, for international justice, and I think there's a bit of hypocrisy in the international community. They talk about the life of these courts, but you know, we don't have a police force, we don't have a territory, and if states don't turn over the people that we indict rightly within our jurisdiction and jurisprudence, then we can't try them. So put up or shut up, really, for the international community. If you want it done, hand them over. And if you don't want it done, be courageous enough to say you don't want it done, but don't blame the courts for things they have no power to do. I think that's very important. So I think that our most controversial development is this Perisic case, and in January of this year, we had oral argument, and the judges, quite rightly, gave us questions they wanted answered. And I always like that, because then we know what their concerns are and we have the opportunity to address them. And I think there were 7 or 8 questions. 4 of those were directly relating to the Perisic appeal at the ICTY, which was decided completely against our position on aiding and abetting. And so we're very concerned about that. And it was basically that the assistance you give must be specifically directed to the crimes. And it appears it was a very, I think, a very confused and illogical decision. 4 judges in the majority, 3 separate opinions in that, 2 of the judges joining in one, and another judge in a separate opinion in the majority. But it seemed to be that I must specifically direct my assistance to the crime. And they said that's a separate element. But interestingly, for those of us who practiced criminal law for a long time, they said, but you know, you don't always have to prove that element separately. Sometimes it can be part of another element. Well, Criminal Justice 101 says if you have an element of a crime, you must always prove it beyond a reasonable doubt. But they said it's a separate element. And if you have remote actors, which most of these high-level accused are going to be, then you definitely have to prove it. And you have to look at things like, they even mentioned, you know, this Perisic guy, he was part of the military in Serbia, and he was giving aid to a group that wasn't 100% criminal. Well, even the mafia probably is not 100% criminal. And you couldn't tell that the bullets he gave them actually were used for those crimes. Well, you now, I guess, have to write, use this for crimes, don't use this for crimes. So the logic, I think, was a little interesting. But Mr. Taylor, of course, is remote. And our judges at trial said this is not a separate element. It goes to prove whether your assistance substantially contributed to the crime. So we have these same issues in Taylor very much ruled against us in Perisic. The one saving thing in Taylor for us is that Mr. Taylor testified for 7 months. He liked to hear himself talk, his attorney liked to hear himself talk, and so it went on for 7 months. And during that time, Mr. Taylor said things he probably should not have said. And one of the things he said was that as of April of 1998, anyone giving assistance to the RUF would know they were giving assistance to a group engaged in terror. Now, hopefully that will get us over the hump if our judges go along with the Perisic appeal. Now, why are we so concerned about an appeal from another court? You know, international crimes are supposed to be uniformly viewed, and there should be a set of law that is applicable no matter what court is trying these international crimes. And that's one of the concerns I have about the ICC. I think it's deviated a bit from the body of jurisprudence, but I think I'm a lone voice in that concern. So this body of jurisprudence that has been established by the ICTR and the ICTY, who basically have given us the jurisprudence for international crimes, our statute, I think quite rightly, in Article 20 of our statute, said our appeals chamber shall be guided by the decisions of the appeals chamber of the ICTY and the ICTR. So that's why we're so concerned about that. And what we wanted to point out to these judges is, yes, you should in general, but this decision, number one, we think is wrong on law and facts, and number two, is so confused that it has very little precedential value. But far and away, I think that's the most controversial development impacting us over the last
Since
year.
you picked that, Brenda, let me jump over to Serge and ask if you have anything you want to add to that discussion, since it was out of your tribunal.
Yeah, indeed, a number of comments I wanted to make in this regard too. But if you ask me more general, what has been the most difficult over the last year, I'm coming back a little bit to what you said as the first question to me. In relation to a number of acquittals which have quite shaken, I would say, the tribunal. And of course, as a prosecutor, you are very much unhappy about these decisions, but it is much broader than that. I would say I've never been as frustrated as a prosecutor in all my career as I've been over the last 10 months. And as Fatou said rightly so, as a prosecutor, you can, of course, live with acquittals coming from a civil law country. As a prosecutor, I've even asked a number of times in the courtroom for the acquittal of an accused. But in relation to a number of the acquittals we had at the tribunal, knowing the evidence, knowing the legal framework in which we are functioning, and I think knowing what is right and wrong intuitively somehow, I feel extremely disappointed by a number of decisions which have been taken by judges, where at the same time, as a party in the proceedings, we have no other choice, as frustrated as we are, to accept these decisions and to limit ourselves to the use of all legal means to challenge these decisions. And of course, we had first the Gotovina acquittal in relation to Operation Storm, followed very quickly by the Perisic acquittal, and where we were very much surprised because this specific direction, new element which has been introduced, has never been present in our jurisprudence over the last 15 years. It's really a new element which has been introduced. And the first instance judges who had convicted General Perisic. General Perisic, he was in Belgrade, so with Serbia, the chief of staff of the Serbian army, and he was providing support to the Serbian forces in Bosnia. And the first instance judges who convicted by majority made very, very clear in their judgment that, yes, he provided substantial support, which was also used to commit crimes, and yes, he was aware that crimes were committed. And this was, according to our usual jurisprudence, substantial support and knowledge about the crimes committed was sufficient. And now this new element is introduced, which almost destroys the entire concept of aiding and abetting, because if there is an almost intentional element by specifically directing the crimes, you are becoming a kind of co-perpetrator. And also by creating the remoteness issue, by saying if an aider and abetter is close to the crime scene, a conviction is still possible. But if he is remote, then you need this kind of specific direction. What is the difference between, if you're providing weapons or support to, let's say, a terrorist group in Afghanistan, if I'm giving them the weapon here to be used in Afghanistan, or I'm traveling to Afghanistan and providing support there? So the the potential negative development for international justice is quite huge. And of course, we are arguing that in our other cases, we have two other ongoing appeals proceedings where the appeal chambers are differently composed, where we are asking the judges not to follow this Paris State jurisprudence, and where we put a number of arguments forward, saying that, of course, it's not supported by the jurisprudence of our own tribunal, it's not supported by international justice principles in general. So we will see what will be the decisions in those two other cases by the end of the year, but we already see the direct impact of this jurisprudence in a more recent acquittal in Stanisic-Sematovic. Now, Stanisic-Sematovic, they were acquitted a few months ago. They were the number 1 and number 2 of the intelligence service in Belgrade. And during the war, they put in place special units like Arkansas Tigers and others. Special units mainly composed by criminal elements, hooligans, who were hired for the specific purpose to participate in ethnic cleansing campaigns in Bosnia. So when we were watching the judges pronouncing the judgment, we were absolutely convinced that it would be a conviction, because the judges started by saying, yes, they have created the special forces, yes, they have armed those special forces, yes, they were controlling the special forces, but we acquit because there was no evidence that all this support was specifically directed to the commission of those crimes. I'm a little bit simplifying the issues, of course, but again, we see that in a case where I never ever would have doubts about a conviction, we see an acquittal based already on this new appeals jurisprudence. But again, you started by saying that we are believers and optimistic people, so I very much hope that the other appeal judges in those other cases will have a very, very close look at this jurisprudence, and that they will not follow this precedent. Thank you.
Well, if one was a conspiracy theorist, they might be tempted to connect the dots between what's going on in this line of cases and, to make it relevant to our theme of this year's dialogue, the possibility of intervention in Syria. Because the theory is that if the United States and other countries give aid and support to the rebels in Syria, and then they do bad things, the U.S. government and the people who gave the aid and support do not want a precedent that would put them in the dock or even cast them in a bad light. And this, I believe, is what's going on in the very public spat between Frederick Herhoff and Ted Marone about these decisions. Is that public dispute affecting the prosecutor's office at all, or are you just sort of ignoring it?
Look, of course, we are fully aware that there is a big debate ongoing, but you will understand that the prosecutor of our tribunal, which I think has, despite all this discussion, achieved a lot over the last years, I would, of course, not participate in any conspiracy theory debates. We remain concentrated on our remaining cases, Karadzic Mladic, because the victims' communities are expecting that we are bringing those cases to a good end. And in relation to this jurisprudence, we absolutely dislike, and we profoundly think that it is wrong. We will challenge it through the legal ways. But you will, of course, understand that I don't think it's helpful to have all this debate now in addition on conspiracy theories. I think that's not for us to do.
Well, let's go back to Hasan, back in order, and things are relatively, compared to this, quiet, going well as you're wrapping up. Is that correct? What is the most controversial thing that you've been facing lately?
Well, I mean, we've had successes, but we've had setbacks also in the past 12 months. And as Fatou said, as prosecutors, we have to take in the setbacks to their acquittals. And for us, in the past 12 months, we've had one case, what we call the Government 2 case, in which 2 former senior cabinet ministers of the interim government were acquitted by the appeals chamber. They had been convicted by the trial chamber of conspiracy to commit genocide, as well as direct and public incitement to commit genocide, based on their involvement in the removal of the prefect of Putare and the installation of a new prefect. On appeal, there was no issue of facts, there was no divergence on facts, and there was no question of law involved. It all turned around the interpretation of the facts as established by the trial chamber. The trial chamber went one way, inferred a certain consequence from the facts, but the appeals chamber went the other way. Basically, what happened was Butare was one of the last places where you had any killings of Tutsis taking place during the genocide. Because at the time of when the genocide commenced, it had a Tutsi prefect. It had a Tutsi prefect, and so the killings did not commence. He fought hard against the killings of Tutsis. He was criticized by the government, by the interim government, as being inactive. And of course, being inactive at the time in Rwanda had a certain connotation, because the killings of Tutsis were referred to as work. So if you were said to be inactive, of course, it meant you were not involved in the killings. So he was criticized by the government officially for being inactive. Then the president of the country, a prefect, by the way, for our American colleagues, I think is like a governor of a state here, like the governor of the state. Because of this criticism, the government took the decision to remove him and to have him replaced. And it took the whole president of the interim government, together with these two accused, who were cabinet ministers, coming into Butare at a ceremony organized for that purpose, public ceremony organized for that purpose, to criticize him and have him removed. And then 2 days later, they came and installed a new prefect who was not Tutsi, but who was now Hutu. And of course, then the killing started and accelerated. And so the question was this removal of the prefect and the installation of a new one part of the strategy of ensuring that the genocide took place in Butare? Or was it just a simple administrative measure of change of prefect? The trial chamber took the position that no, looking at all these facts together, which I have mentioned, which were not disputed on appeal, this was clearly a strategy by the government to make sure that killings, the door to killings was opened in Butare and that the genocide was implemented. Because as soon as he was removed and replaced by a Hutu, the massacre started in that particular place. On appeal, because the Court of Appeal felt that the other possibility that he was removed for simply as an administrative measure had not been ruled out. But the trial chamber, of course, had specifically alluded to that and explored it and discounted it and said it was unbelievable that he could simply have been removed for administrative reasons. And looking at all the facts, it seemed it was clear that the intention was to make sure the genocide took place. So that as a result, the appeals chamber acquitted both of them of conspiracy to commit genocide. It's a big setback for us because they were senior people, members of the government, cabinet ministers, the kind of people who don't go down to the streets to wield machetes or guns, etc., but who take decisions in the cabinet about removals and who work in very subtle ways. But in terms of the law, of course, what this meant was that the appeals chamber was not then deferring to the trial chamber in terms of its the inferences to be drawn from the facts which had been established. And what we would like to see clearly is the appeals chamber deferring more to the trial chamber in terms of findings of fact, in terms of inferences that should be drawn from the facts which have been proven. This is particularly important because a trial chamber, which takes years to do a case, hears all the witnesses, reads the record many, many times, probably has a better grasp of the witnesses about their credibility, about the nuances, about the context of the case, etc. Yeah. So it was a setback for us, but we hope that the appeals chamber will, in future, give more deference to the trial chamber, and we may then not have this kind of acquittal.
I mean, that's part of the hybrid nature of the tribunals. In the civil law approach, there is much less deference than in the common law approach. Were the judges in this case from civil law countries?
It's a mix.
It was a mix,
yes,
and you see that playing out. There's a
law
Darwinian struggle going on in your courtroom there. Yes. Let's go over to Fatou. Oh, there's so many things going on. I will be very curious to see what you pick as the most controversial issue this year.
Really, I could pick them all. I think that the confirmation of charges decision in the Laurent Gbagbo case is one of those controversial issues that we have at the court this time. In June of this year, the 2 out of the 3 judges who were sitting on the confirmation of charges for President Laurent Gbagbo, the former president of Côte d'Ivoire, decided that our office, my office, has to present further evidence, and they also decided to adjourn the decision in the confirmation of charges until we provide that evidence or we conduct further investigations. Of course, this is something that could potentially be very serious and has serious implications for all other cases that are coming before the ICC if this standard is allowed to stay. And immediately I sought leave to appeal. I sought leave to appeal mainly for the judges of the appeals chamber to have the opportunity to look at what is the correct applicable standard, evidentiary standard that has to be applied at that stage of the proceedings, which is the confirmation proceedings. I also wanted the chamber to decide, or want the chamber, the appeals chamber, to decide whether each incident that underlies the contextual elements of the crimes against humanity we have to prove, because this is what 2 out of the 3 judges are saying, and also whether the pre-trial chamber judges can actually also ask the prosecutor to amend the factual elements of our charges. So this I think is important to go forward with it, and we were a bit apprehensive that we would not get the leave to appeal, but we do now. We have the leave to appeal, so we will put the issues before the judges of the appeals chamber. But importantly, one of the judges, Judge Fernandez, dissented from the decision that was taken by the 2 others, that she did not agree that with her colleagues on the decision that they have taken. But as we know, she's in the minority, so we have the appeal decision, we have the leave to appeal decision now, and we are going to, it was partially granted, not even fully, but I think it's fine. You know, we can go ahead with the issues that we want to present before the appeals judges. So for me, that is quite an important, but has also created a lot of controversy. You know, yes. About
sometimes as an academic, this is all in the abstract, but Stephen Rapp had sent Paul Williams and I and the PILPG into Côte d'Ivoire a couple of years ago to do a needs assessment. And from talking to literally hundreds of people about the situation, I can tell you that the outcome of this case could have a profound impact on peace and justice in that country.
Absolutely.
So let's cross our fingers on that.
But I also think that what it is helping the office to do, because presently we are engaged in looking at, you know, our strategies, especially whether we have to be as trial ready as possible before we go for confirmation of charges. So this is also one of the issues that is coming at a time when we think that we can address it more closely than before. The other thing that I wanted to also mention, which has also, I think, created a lot of controversy, is about holding trials in The Hague or holding it in Nairobi, Kenya, regarding the Kenya cases. Fortunately, I think, the judges have now come up with a decision that it should be, the plenary of judges, you know, have come up with the decision that the cases should be held in The Hague, which I think it's good under the circumstances. I think the office, as much as we want these cases to go as close to the communities as possible, but I think we need to be realistic also. And it would have presented tremendous challenges for the office, even for the government of Kenya, for these trials to be held. I mean, we are talking about the president and the deputy president of their country, in their country. So I think it would have been very difficult for us as an office to do that. Another one also is still regarding the Kenya cases, is about the presence of Ruto, Deputy President Ruto, at trial. We had a decision from the chamber saying that Ruto can, and it was a majority also of the judges, that says that he can be excused physically from the trials and can only be present not for the entire trials, but at least for the opening statements, the closing statements. Maybe he will be required to be present during the delivery of judgment and maybe sentencing and apparation, but otherwise he does not have to be present in The Hague. I immediately requested for leave to appeal this decision, which you know, we are appealing. We're before the appeals chamber, and just a few days ago, the appeals chamber has granted us the suspensive effect that we requested for that decision, because the trial is starting on the 10th of September. And what the Court of Appeal is going, the Chamber of Appeal is going to decide will have an impact on that. So we have suspensive effect for the trial chamber's ruling, which means that Ruto will now be present throughout until the appeals chamber come up with their final decision. So this, I think, was something that was also quite controversial for the office, because I think that we are waiting, of course, for the final decision of the judges, but I think that we have to send a message that no one is above the law. You know, whether in spite of your standing, your status, if you are an accused person before the ICC, and the statute says that accused persons are required to be physically present in the ICC, no matter what your status is in society, it shouldn't change that.
You know, I know how eager the audience is to ask questions of the prosecutors, and some people have come from very far just to have an interaction with you. So with your indulgence, I'd like to skip the last question and just open it up to the audience questions. Is that all right with the prosecutors? Okay, just raise your hand and I'll point to you and you can ask a question. And I will repeat the question as well. We don't have a microphone that can go around, do we? Okay. Let's begin with that gentleman there. That's you, Hyder.
Thank you very much, Mike, for moderating the discussion on Sunday night. Thanks to the prosecutors for traveling so far to be here and for sharing your very insightful remarks. My question is for Madam Bensouda. I believe you are...
I expected that.
Your predecessor said that it wasn't possible to determine whether Palestine met the statutory requirements for statehood in order to implicate the court's jurisdiction in the absence of a decision by a competent organ of the United Nations. And since then, the General Assembly has recognized Palestine as a state, and so explicitly by granting it observer state status. So I'm wondering if you believe that Palestine does now meet the requirements to seize the court, and if so, what sort of response or maybe even pressure your office might face from Israel or maybe some other governments as well.
Now, Hyder's a national champion moot quarter, so I assume you all could hear because his voice projects. But does anybody want me to repeat? Raise your... Okay. All right. So the question was, now that the General Assembly has taken action on Palestine's status, will that change how Fatou's office looks at that issue of the referral from Palestine to the ICC?
You referred to the referral from ICC, from Palestine, and the position that my office has taken about not being able to take the case because of the status of Palestine then. Of course, that has changed. That has changed now, and we have had discussions with authorities from Palestine, and I have told them the position of the office, that the ball is in their court and they need to decide whether they want to come back to the ICC and either make a declaration, a new declaration under the current dispensation, or ratify the Rome Statute if they want to. You know, I think in that case it would, in both cases it will be easy for the ICC to proceed. But I made it clear that just because now they are in this current position, we're not going to jump back on the case and say we move forward. It is for them to re-engage my office.
Now, Bill Shabas, you had your hand up. Do you want to talk into this microphone?
Thank you all for a great presentation. And we have a huge amount of talent and experience here. I think almost all of the prosecutors have worked for more than one tribunal. Some of them maybe multiple tribunals. So I'm wondering if you might turn your minds away from your tribunal and to the theme of the whole workshop, which is on the Middle East, and to speculate a little bit on how international criminal justice might contribute to the Middle East right now, in a general sense. Suppose, as a hypothetical, the Security Council had some kind of an epiphany and decided to behave in a principled, honest, democratic manner, and so adopted a resolution unanimously referring the situation in the Middle East to the International Criminal Court. What should we do?
Who would like to address that? Just raise your hands. So
Who would like to address that?
Brenda.
Who would like to address that?
All right. So, Fatou, you start us off, then we'll hear from Serge and Brenda.
Yes. Of course, if you will notice, I have been trying, or I have been rather quiet regarding this, the issue of a referral to the ICC of the Syria situation. Just like other situations in which I have seen that the Syria or that particular country is not a state party to the Rome Statute, and therefore we will only get jurisdiction if we were to have a referral from the United Nations Security Council. And I've always made it clear that we don't go to the UN Security Council and say, give us a case. You know, the states parties help us to do that, and I think other international organizations also help to push that to happen. And so far, unfortunately, it is not happening. I do not also think that it is likely to happen for many other reasons, as we all know. So I try to explain that, you know, I think that the situation in Syria is no less serious than the situation in Libya or the Darfur situation. And those situations have been referred to the ICC, and we have been able to proceed with investigations and prosecutions. So one just tends to wonder, you know, as you said, why the right thing is not being done. And the cases in Syria referred to the ICC. We wait. Of course, we do have our own challenges, and I know that an investigation, a Syria investigation for the ICC will also present huge challenges, but that will not say that the ICC, that my office will not be also responsible enough if we were to get a referral from the UN Security Council to investigate into the crimes the crimes that have been taking place there for now 2 years, and over 100,000 victims and counting.
Serge, your take on this?
Yeah, what is the solution for Syria? Of course, most important would be that the conflict ends, which would then only allow to look into different models. And having worked for 2 years, and having lived 2 years in Lebanon, and having been a number of times in Syria, I know perfectly well that a judicial solution imposed from outside will not be a solution which is satisfactory to people on the ground. If there is one lesson learned from our tribunal, we have been in existence now for, as several said, for 20 years. In the early years where we were alone on the market to provide some judicial process, and where today we have partners on the ground, but we see that after 20 years, for many people in the former Yugoslavia, the decisions of our tribunals are still not accepted, and the revisionist approaches and considering persons prosecuted in The Hague as heroes locally, it's still an unfortunate reality. So I think that if one would move towards a judicial solution for the after-conflict Syria, that independently from the question to go or not to go to the ICC, a regional and national solution will be necessary. and that a mixed approach, a hybrid approach with an international support but national ownership would probably be the best solution based on my limited experience in this regard. So I would very much be in favor of an integrated solution with a very strong national ownership, but with the necessary expertise and support coming from outside.
Brenda?
If a court were given the mandate, or a body were given the mandate, it's really simple what a court would do, because politics should not play into what a court does. The ICC is the International Criminal Court. All the other courts are criminal courts. They're not international diplomatic enclaves. So if we're given the mandate, we do what we can to the best of our ability. We investigate, and if we find sufficient evidence against anyone, not just the government, you don't go in thinking it's just this group or that group, then we bring charges. But I think that one of the things that should happen is that when the UN decides that it wants to refer a situation, then it has to back up that decision by giving all the support necessary for the court to do its job. So protection for investigation, protection for people that you're talking to, pressure that decisions of the court to indict will carry a Security Council mandate that those people be turned over or there are consequences. And I think also that we look at the benefits that may accrue from international prosecutions as opposed to national prosecutions. First of all, if the international courts are staffed appropriately and are not playing politics, it will be based on the law, and we're supposed to be the rule of law. So if there's not sufficient evidence, you don't go forward. If there is, you go forward no matter whether these people are popular, unpopular, out of the country, in the country. That, to me, is a benefit that doesn't always happen at the national level. I think you go in while the conflict is ongoing. We went into the former Yugoslavia while the conflict was ongoing. You may need to do that to get evidence you may not find later. You may not be able to get the people at that time, but I think your investigations begin as you are given them. Also, there were remarks earlier about timing of judicial responses to these crimes, and that sometimes you have to wait. I think that timing is more important for national than for regional or international solutions. Because at the national level, as was rightly said, if you are emerging from the conflict, you have a very fragile government, you have a very fragile society trying to reintegrate, and you don't want to have the government prosecuting its opposition, because that will simply fracture this very fragile effort to emerge as a unified country. Whereas if an international body is doing that, the government can say, we're not in charge of that, it was mandated by someone else. And also an international forum gives you the opportunity to prosecute those who are now the government of the country, because often they deserve prosecution as much or more than the ones who lost. And also then the national government can focus on infrastructure, economics, social improvement for its people. So I think there are some benefits. But bottom line is, if you're given the job, you do the job as you would in any national setting to the best of your ability. You investigate while taking all measures to protect people that you speak with. And if you have sufficient evidence, you ask the judges to allow you to move forward to trial.
Andrew, did you want to add something?
Yeah, I mean, it's interesting because Fatou and I, several years ago at the ICC, worked on the Sudan case, which is a very similar situation to that of Syria in the sense that we were dealing with a state, Sudan, that had not signed up to the Rome Statute, the international treaty creating the court. The case was referred by the Security Council to the ICC, and Sudan simply turned around and said, well, actually, we have no obligation to cooperate with the court at all because we didn't sign up to the treaty that created this body, so we don't have to cooperate with you. Now, there's an argument that they have got to cooperate because they're a member state of the United Nations, but you recall, Fatou, how almost impossible that case was to investigate because the Sudanese controlled access and egress from Sudan for members of the investigative team from the ICC. I think in the end we ended up going 4 times. We got the runaround. Extremely difficult to investigate the case, extremely difficult to protect witnesses on the ground. Now, indeed, eventually, within that case, cases were put forward, there were arrest warrants, but it's very, very, very difficult to go into a country and try and investigate when the country itself is arguing that there's no mandate. And indeed, in the situation in Sudan, there was very little political will to press for the ICC investigation because other interests came to the fore, like actually peace. I mean, I know we talk about there's no peace without justice, but leading countries that were signed up to the Rome Statute did not give an enormous amount of political support to the Sudan investigation because they had other interests. Now, that's the negative, but I think the positive in it is that even if the Security Council, as Bill was saying, were to have this sort of moment of epiphany and actually do it, I think even in itself, the referral, I'm not sure how much study there's been on this, whether it has a deterrent effect. I mean, I think there is an argument to say that once leaders of a state know that the situation has been referred, perhaps practically, they may, even though they're not going to cooperate at that moment in time, they may think twice about committing further crimes. But if you look at Sudan and how long ago that case was referred to the ICC, and I think how many years ago is it now? It's 8 years ago, and how very little distance has been run because of the lack of political will of the international community. It's not very encouraging, and it simply proves the point that without the political support of the countries who actually established the International Criminal Court, it can't work, basically. That's the problem that exists, and that's what puts Fatou in such an impossible situation in trying to answer these questions, because the court doesn't operate in a political vacuum. You know, politics plays such an enormous role in this. I mean, if you look at Omar al-Bashir, who's been indicted by the court, you know, traveling freely to many places, including countries that are signed up to the Rome Statute, who should actually arrest him. I think he's been to several countries. So we can talk about justice, but there is also a political reality that you have to consider in the operation of these courts. I mean, I could go on because it's also affecting the court where I work. Anyway, yeah.
Okay. So we have 5 minutes, probably time for 2 questions. Mohammed and Diane had their hands up. You've got yours answered. Let's go to Diane. And Diane, if you wouldn't mind just running down here, then we can hear your question. I won't have to truncate it.
Thank you, Michael. This plays off a little bit on some of what just transpired, Brenda's comments and some of the others. I wonder if you could respond to this notion that international criminal justice has a role in affecting remorse among perpetrators. It seems to me that that is an aspiration for societal reconciliation, but I wonder if it's a justification for postponing accountability. Brenda suggested we should go in right away. I come from the state of Georgia, where people speak without a lot of irony about the War of Northern Aggression, which occurred 150 years ago today. And does that mean there should be no accountability for centuries until societies can heal? So I'd love a response to that.
Who wants to tackle that?
Yes, I wanted to come in a bit earlier on the previous question. I think in relation to the Middle East, of course, the situation clearly is such that there is a need for accountability for what is going on there. It's important, I think, that the principle of equal application of the law is respected. That's very fundamental. If we don't do that, we run the risk of undermining a lot of the work which has been going on, and throwing the credibility of the justice process itself into question. There is a lot of criticism of it at the moment, that it's sort of lopsided one way, that we go for soft targets, we leave the hard targets aside, etc. But we have to make an effort to make sure that the law is applied across the board, whether it's a difficult case or it's a simple case. It's important both for justice and as well as for peace, that there is a perception that an effort is being made to apply the law to all these situations in which accountability is necessary, including particularly the Middle East. But coming back to the issue of remorse, I think the guest speaker raised an important point. Remorse is important for reconciliation. But of course, as a prosecutor, I'm more concerned about securing a conviction, about making sure that my charges stick in court, and I do get a conviction. But reconciliation also is important in the sense that, for instance, for the ICTR, the ICTR statute itself speaks in terms of reconciliation being hopefully a byproduct of our work. How do I, as a prosecutor, fit that into my work? One of the ways in which we've tried to do that is through the negotiation of guilty plea agreements. The negotiation of guilty plea agreements which specifically encourage or call for the other party to issue a statement of remorse. And we've succeeded in at least 2 cases in securing 2 statements from 2 accused, publicly made in the courtroom, expressing regret at what has happened in Rwanda and apologizing for what has happened there. But of course, you also need, in addition to these expressions of remorse, you need a kind of acceptance from the other side as well, or else there is no reconciliation. It's happened only in 2 cases in our own situation. Most of all the others really have not made any expressions of regret or remorse. More often than not, they regard themselves as victims as well. They regard themselves as people who have been wronged. And that is the problem. As the prosecutor, of course, I am more immediately concerned in making sure that my charges stick. If there is room, if there is a window of opportunity for me to marry that accountability with remorse and reconciliation, then I will try and do so. And as I said, my guilty plea negotiations provide me with that opportunity.
Maybe that's a good place to close. Does anybody else want to comment on remorse? Okay, Brenda, and then Serge. Yeah.
I prosecuted in the United States military for about 18 years, and people there always had excuses for what they did. It's unfortunate that it happened, but I didn't do it. It's unfortunate that it happened, but it was an accident. It's unfortunate that it happened, but they asked for it. And I don't see it any different in the international community, especially people who are responsible for these continuing horrific crimes. They will justify it to themselves and their followers, and I don't know how you get remorse. In terms of accountability and reconciliation, I think human beings require accountability for wrongs done to them. The criminal justice response is one mode of accountability in these situations. You have truth and reconciliation commissions. For people who have limited involvement, you may have traditional justice. And then you have the criminal justice response, which is typically for those who are most involved in the most egregious crimes. And I think that's important. And I think that society looks to that and sees that as one legitimate response to horrible crimes. And I think that builds reconciliation. Because if people are wronged and there is no justice in their eyes, then you're not going to have reconciliation. So I think justice, including criminal accountability for some, is an important part of reconciliation. And I think these international courts are simply one response to one issue, accountability, that is a whole plethora of issues that states have to have addressed to emerge from these crimes. And we seem to be, I think, unfortunately, sort of shouldered with creating a better future for these people. And we are simply one part of one package, and an entire array of packages is necessary in order to truly move these states forward.
Serge, you get the last word.
Only to say that the example Prince Zayed took was in relation to President Plavšić. She was in fact the only woman prosecuted by the ICTY, and she was a member of the Bosnian presidency during the war, and she indeed, it was a guilty plea, and she had a reduced 12 years sentence. She served in Sweden, I think. And once she had served her sentence, she was taken by a government plane back to Republika Srpska, where she was received with all the honors, and where then she said that, of course, she cooperated to have a lower sentence. We have seen in the courtroom in The Hague a number of cases where perpetrators apologized or showed remorse, and when victims were present, it really had a very, very strong impact. And one of the main questions about it is that if they show remorse and apologize, it's much more difficult for political leaders who still use nationalism to win elections to rely on the crimes of the past. And to finish with two examples in this regard, when I had the opportunity to go for the first time to Srebrenica, to meet with the mothers of Srebrenica and 100 survivors. It was 3 years ago. The same day, the political leader of Republika Srpska said publicly that the genocide never happened. And even more recently, 2 years ago, when Serbia elected a new president, in his first interview, he got the question about Srebrenica, and he said that probably a number of people have been killed, but that it was, for him, not genocide. And there was very, very little reaction from the international community saying that this is unacceptable. So I think that remorse is a very important issue for the perpetrator as such, for the victims, and I think it helps very much reconciliation, because, of course, for victims, seeing acceptance of guilt is a very important step forward.
All right, so a few words of conclusion. First of all, if this is your first time here, you have to know how absolutely extraordinary it is to come and see all of the prosecutors on one panel answering your questions. It doesn't happen anywhere else. It only happens here because of David Crane, who makes it happen. David, thank you for that. And these are the modern day Robert Jacksons. And they are the heroes of international peace and justice. So please give me a very, very warm ovation for our panelists. Now, Jim, you want to come up and tell us some logistics?
Thank you, Michael. Thank you very much. We will now take a recess for lunch. We will meet back here at 1:30 p.m. for the Clara Barton lecture, which will be a real treat. And our guest lecturer for the lecture will be Skyping in from Afghanistan. So please be back here promptly at 1:30. If my prosecutors and former prosecutors would please stay behind for a photograph.